Count two, charges you with the offense of malicious destruction. Mr. Layman, I intend to keep talking, and I'm going to keep talking because you are already tending to make this job more difficult than it needs to be. I say that because this is a simple procedure, and when you're laughing, it suggests to me more that what I'm suspecting is the truth, that you're intentionally trying to impede the role that I have, the role that Mr. Wergau has, the role that the Alpena County Circuit Court has, or the role that even your own attorney has.
Picture this. The man walks into arraignment facing 4 separate felony files, and before Judge Hunter even finishes explaining why they're there, the guy's already making hand gestures and laughing. Judge Hunter, filling in from the 46th Circuit, immediately notices the disrespect and calls it out on the record. Matthew Layman's own attorney admits he hasn't even gone over the charges with him yet. When the judge asks Layman directly if he understands what he's facing, Layman shrugs it off with, "I don't know what that means." From there, Judge Hunter walks him through file 1 line by line, threatening an act of terrorism, false report of terrorism, and interfering with a crime report, with the top charge carrying up to 20 years. It's a rough start, and it only gets messier from here.
Turning to file number 25-3401FH. In that particular case, the information charges you with the offense of count 1, malicious destruction of fire or police property. In that case, the prosecutor charges that on or about July 21st of 2025, that you did willfully and maliciously destroy or injure certain personal property, to wit, a security or surveillance camera, belonging to or possessed by the Alpena County Jail, contrary to statute. That offense is also a felony offense, and the maximum punishment for that felony offense is 4 years in the state prison system and or a fine of up to $5,000. Did you have a question, sir?
Oh, no, I was just pointing out, I'm in the exact cell where I did it. It was that camera up there that I broke.
Mr. Layman, let me make this more simple for you. This is not a hearing where I'm making factual determinations. This is not a hearing where I've yet sought input from you except as to limited questions. And those limited questions are these following. Have you had a chance to read the allegations against you? Do you understand the charges? And do you understand the maximum penalty? That's it. That's all I'm asking, and that's all I'm permitting. So any of the commentary that you might have, you can save it for your attorney and or for a jury and or for me if you determine to have a bench trial. But the focus of this hearing is not for you to tell me anything else about the case. Do you understand?
Yes, I do, Your Honor.
So do you understand the nature of the charge and the maximum penalty associated with count 1 in the second file?
Yes, I do, Your Honor.
Count 2, charges you with the offense of malicious destruction. Mr. Layman, I intend to keep talking, and I'm going to keep talking because you are already tending to make this job more difficult than it needs to be. I say that because this is a simple procedure. And when you're laughing, it suggests to me more that what I'm suspecting is the truth, that you're intentionally trying to impede the role that I have, the role that Mr. Wergau has, the role that the Alpena County Circuit Court has, or the role that even your own attorney has. If my suspicion in that regard is continued and I make a finding, I'm simply going to remove you from this court proceeding and I'll conduct it with your attorney. However, that's an extreme measure. I don't want to take that action, but I am not going to allow you to turn this hearing into a mockery. And if you continue to act like this is a funny proceeding, I will view you as having waived your right to participate. Do you understand what I've said?
Yes, I do, Your Honor.
Do I need to repeat any of that circumstance more specifically for you?
No, you do not, Your Honor.
Then you should act accordingly. You should listen carefully to the things I'm saying, and you should answer only those inquiries that I put to you.
After that warning lands, Layman settles down enough for the judge to keep moving. File 2 piles on 2 more counts of malicious destruction, a jail structure, and believe it or not, a broom, each carrying a 4-year max, bumped to 6 years once the habitual offender notice is factored in. Then Judge Hunter moves into File 3, and this is where things get heavier. Count 1 is home invasion in the first degree, tied to an alleged assault during the break-in, and it's a 20-year felony on its own. The recitation is dry, but the stakes climbing with every count are impossible to ignore, and what's coming next is the charge that changes the entire tone of this case.
In count 2, you're charged with the offense known as criminal sexual conduct in the 4th degree, force or coercion. The prosecutor reads and alleges that you did engage in sexual contact with another person, to wit, Randy Allen Bridges, using force or coercion to accomplish the sexual contact contrary to statute. Do you understand that allegation so far?
Yes, I do, Your Honor.
That is a Tier 1 offense under the Sex Offenders Registration Act if the victim was 18 years of age or older. It's a Tier 2 offense if the defendant has a prior conviction for a Tier 1 offense. It's a Tier 2 offense if the victim was between the ages of 13 to 17 inclusive. And it's a Tier 3 offense if the victim was under 13 years and the defendant was 17 years of age or older. It's a Tier 3 offense if the defendant has a prior conviction for a Tier 2 offense. Take notice that pursuant to the statute, upon bind over to the circuit court, the district court judge shall order the defendant to be tested for venereal disease, hepatitis B infection, and for the presence of HIV or an antibody to HIV. if that judge determined that there's a reason to believe that the violation involved sexual penetration or exposure to a bodily fluid of the defendant. If the district judge made that determination that testing is not required, then upon conviction, the court must order you to be tested. Do you understand those provisions?
Yes, I do, Your Honor.
The maximum penalty for that offense, it's called a high court misdemeanor. In Michigan, that's also known as a felony. That's because it's punishable by more than 1 year in the county jail. The maximum penalty for that offense is 2 years in the state prison system and or a fine of up to $500. Are you aware of that maximum penalty?
Yes, I am, Your Honor.
With a sexual conduct charge on record, Judge Hunter moves to count 3 in file 3. Assaulting and resisting a police officer, a felony carrying up to 2 years. Then comes the habitual offender math again, and this part matters. Because Layman's already facing a second offense enhancement, every one of these penalties gets multiplied by 1.5. Home invasion jumps to 30 years. The assault charges climb too. It's a lot of numbers thrown at once, but the takeaway is simple. This isn't a minor case anymore, and the paperwork is stacking up fast against him. File 4 is still coming, and it's arguably the most disturbing charge in the entire hearing.
Finally, in claim case number 25-3404FH, the prosecutor alleges that on or about July 11, 2025, with respect to count 1, that you did make an assault upon Thomas Michael Patel Jr. by strangulation or suffocation, contrary to statute. That is a felony offense with a maximum potential punishment of up to 10 years in the state prison system and or a fine of up to $5,000. DNA must be taken upon your arrest. If it was not taken upon your arrest, it would be ordered to be taken upon your conviction. A consecutive sentence may be imposed under the statute if the assault was committed in a place of confinement. Do you understand the maximum penalties associated with that charge?
I do, Your Honor.
You're also charged as a habitual offender second offense notice, meaning that if you were convicted, that penalty would rise by 1.5 times, meaning the maximum penalty is 15 years in the state prison system for count 1. Do you understand that?
Do.
Count 2 charges you with the offense known as assault with intent to maim. That alleges that you did make an assault upon Thomas Jr. with the intent to maim or disfigure said person by cutting or tearing off an ear, contrary to statute. That is also a felony offense. That felony offense is punishable by a maximum of 10 years in the state prison system and or a fine of up to $5,000. DNA must be taken upon your arrest. If it was not taken upon your arrest, it would be ordered by the court to be taken in the event you were convicted, and a consecutive sentence may be imposed under the statute if the assault was committed in a place of confinement. Once again, you're charged as a habitual offender second offense notice, making the maximum penalty for assault with intent to maim up to 15 years in the state prison system. Do you understand the nature of that charge as well as its maximum penalty?
Yes, I do, Your Honor.
You have the right to remain silent throughout these proceedings. If you don't remain silent, anything that you say on the open court record or in any writing could be used against you. You have the right to be represented by counsel. Here, Mr. Pfeiffer is going to do that for you. Mr. Pfeiffer, with that reading, do you have anything formally that you would like to cover further in terms of the arraignment on the information?
There's just one issue. I'm not sure if Mr. Wirgo is aware of this, but count 2 of the last file, the assault with intent to maim, was dismissed at the district court level. So
I was not aware of that. I appreciate that clarification. Is that correct, Mr. Wirgo?
I do believe it is, Your Honor.
All right. And so all of the other charges, though, still remain. Is that right, Mr. Pfeiffer?
Absolutely, Your Honor.
All right. So that is a fair and important clarification. Count 2 in that last file, assault with intent to maim, has been dismissed. Are you now aware of that, Mr. Layman?
Oh, yes. Yes, I am, Your Honor.
Courtrow files a dozen felonies and a defendant who spent half the hearing laughing instead of listening, and Judge Hunter never lost his composure once. He warned Layman, gave him every chance to take it seriously, and still caught and corrected an error in his favor. I side with Judge Hunter on this one. Do you think he should have removed Layman from the hearing sooner? Let us know in the comment. That's a wrap on another epic case, and honestly, I have so many more where that came from. Drop a comment and tell me what you thought, and make sure you're subscribed to Court with Mia so you never miss the next one. See you there.